Morning, everyone. Good afternoon. It's past 10, so I think we'll start um, while we wait for other people to join us as well. Welcome to this event titled Voices of Justice Protecting Lawyers' Freedom of Expression. The topic of this event is close to the mandate of Lawyers for Lawyers, which I'm the executive director of. Sophie de Graaf is my name. Because lawyers are essential guardians of the rule of law, and their ability to speak freely, whether in court, in public, or within their professional roles, is fundamental not only to defending their clients, but also to upholding justice, human rights, and democracy. And yet, across the world, lawyers continue to face intimidation, prosecution, and even imprisonment for exercising their right. The partners organizing this event today, Lawyers for Lawyers, Thai Lawyers for Human Rights, the Law Society of England and Wales, and the International Bar Association's Human Rights Institute, have all been observing these troubling trends and are working on this issue from different angles. And that's why we've come together today to share and discuss two new studies that shed light on these challenges. One exploring the global restrictions on restrictions of lawyers' freedom of expression, and another focusing on the case of Thai human rights lawyer Arnon Nampa. We were supposed to start with the keynote of Ms. Karuna Nundi, but unfortunately she's upheld in court. This is why we hopefully will get her keynote at the end of this session, but we'll continue with the agenda for today. And the first presentation we'll get is from Deborah Long. I'm very pleased to introduce Deborah, who is the International Policy Manager for the Rule of Law and Human Rights at the Law Society of England and Wales. She oversees the Lawyers at Risk program and leads initiatives to strengthen the independence of the legal profession globally. And Deborah will present the findings from the Law Society's new report, When Lawyers Are Silenced, How Restrictions on Lawyers' Expression Undermine Rights, Justice and Democracy. This study highlights how increasing restrictions on lawyers' speech are eroding the rule of law and access to justice worldwide. Deborah, I'm happy to give you the floor.
Thank you, Sophie, and I'm delighted to have the opportunity to speak at this very important webinar. As Sophie mentioned, I'm Deborah Long and I manage the Lawyers at Risk programme at the Law Society of England and Wales. This initiative advocates for lawyers who face human rights violations because of their work, and it aims to protect the independence of the legal profession globally. We engage in advocacy because we, along with our members, are committed to the principle that as part of the global legal community, we must stand in solidarity with our peers worldwide. Lawyers are essential guardians of the rule of law, as Sophie mentioned, and they ensure access to justice, they confront abuses of authority, defend human rights, and uphold the integrity and independence of the legal profession. Yet precisely because of this role, lawyers are increasingly targeted, harassed, intimidated, and silenced simply for doing their job. One of the most troubling trends we've observed is the growing use of legal and disciplinary measures to suppress lawyers' freedom of expression. Now, we've seen this across all regions, that lawyers face sanctions, threats, and even criminal prosecution when they speak out. As Sophie mentioned, to draw attention to this issue, we will be publishing a thematic report called When Lawyers Are Silenced, When Restrictions on Lawyers' Expression Undermine Rights, Justice and Democracy. And this will be published in January to coincide with the Day of the Endangered Lawyer. The report draws on real cases, including that of Arnon Nampa in Thailand, to illustrate a disturbing global pattern on interference with lawyers' freedom of expression. Through this work, we've identified three main categories of laws being used to silence lawyers. First are laws restricting expression, such as sedition, criminal libel, or insulting language often applied arbitrarily. Second are counter-terrorism and national security laws. These are frequently vague and carry severe penalties and undermine fair trial guarantees. And the third measure are professional regulations and codes of conduct. This is where disciplinary measures and disbarment are misused as tools of control. So these are legal tools being used for illegitimate purposes. It's widely recognised that freedom of expression is a cornerstone of any democratic society. It enables people to speak out, share ideas, challenge power, and push for change. For lawyers, this right is vital for their work and service. It underpins their ability to advocate in court, promote legal reform, speak out against injustice, and educate the public, whether that's through media, publications, or social platforms. Yet, as the UN Special Rapporteur on the independence of judges and lawyers has noted, she's seen many instances in which lawyers have come under attack when pointing out difficult truths, such as problems in the administration of justice, the existence of different forms of justice for the rich and for the poor, or cases in which fair trial standards were breached. When lawyers are prevented from speaking freely on such issues, the rule of law and institutional independence are weakened. Lawyers are a key check on state power, and their voices are essential for accountability. Now, international law recognises this important role. Principle 23 of the UN Basic Principles on the Role of Lawyers explicitly safeguards lawyers' freedom of expression. Also, Article 7 of the new Council of Europe Convention for the Protection of the Profession of Lawyer reinforces this protection. It has also been consistently upheld in the case law of UN bodies and regional human rights mechanisms. Now, of course, the right is not absolute. Lawyers may face restrictions where these are lawful, necessary, and proportionate. Their professional obligations, such as client confidentiality or the fairness of a trial, can justify certain limits. But what we have seen, and Lawyers for Lawyers have seen, are far too often restrictions go beyond what international law permits and are used to silence dissent and curtail justice. We will hear more today about the human rights violations faced by lawyer Arnon Nampa. Unfortunately, this is a pattern repeated globally. And I wanted to share another example from a different jurisdiction. In Egypt, Hoda Admel Manin is a respected human rights lawyer and former member of Egypt's National Council for Human Rights. In November 2018, she was arrested for documenting human rights violations through the social media pages of the Egyptian Coordination for Rights and Freedoms. She was forcibly disappeared for 21 days, held in pretrial detention for 3 years, and later sentenced to 5 years in prison by the Emergency State Security Court, an institution widely criticised for its lack of due process. Unfortunately, despite serving her sentence, Hoda was recharged on identical grounds in 2023. This again is a troubling example of Egypt's practice of recycling charges against individuals. Today, unfortunately, she remains imprisoned, and there are grave concerns for her deteriorating health and continued denial of justice. Cases like Hoda and Nampa like this show how restrictions on expression not only harm individuals, but also ripple across the entire profession. For those directly targeted, the consequences are devastating. There's a loss of livelihood, loss of liberty, and immense personal and family hardship. But beyond the individual, such actions create a chilling effect. Lawyers may avoid controversial cases or refrain from speaking out altogether for fear of reprisal. This climate of self-censorship undermines open debate, legal reform, and government accountability. Accordingly, states, international institutions, and legal professions all have a role to play in ensuring that lawyers can carry out their professional duties without fear of reprisals. Therefore, we have a number of recommendations for actions at all levels. First is a review of laws to ensure they comply with international standards on freedom of expression. Second, the repeal or reform of vague or overbroad provisions that can be abused. Third, the immediate release of lawyers arbitrarily detained for their expressed views. And lastly, strong and coordinated international action to condemn attacks on lawyers and to ensure that they can carry out their duties without interference. Therefore, in closing, our message is clear that safeguarding lawyers' freedom of expression is in the interests of everyone. It strengthens the foundations of justice, upholds human rights, and reinforces public confidence in institutions. Thank you. Back to you, Sophie.
Thank you, Deborah, for that comprehensive and eye-opening presentation. And we look forward to reading the full study when it's released in January, and I suppose it will be available on your website by then so that we can access it.
Yes, it will be.
Perfect. And as Deborah mentioned, we'll continue with the presentation of the study Lawyers' Freedom of Expression on Trial, the Case of Arnon Nampa in Thailand. And this will be done by my colleague, Natalia Segura Diaz, who is a program officer at Lawyers for Lawyers. This report examines the multiple prosecutions of human rights lawyer Arnon Nampa under Thailand's lèse majesté law and their implications for the independence of the legal profession. Natalia, please go ahead.
Thank you, Sophie, and good morning and good afternoon, everyone. Thank you for joining this webinar. And I would like to start by thanking the Law Society, Body, and Thai Lawyers for Human Rights for organizing this event with us. And also I would like to thank the students of the Master Program in International Crimes, Conflict, and Criminology at the Free University of Amsterdam for their contribution to the preparation of the report I will present today. So as Deborah was clearly outlining, safeguarding lawyers' freedom of expression is fundamental for the rule of law. Building up that framework, I would like to introduce our upcoming report, Lawyers' Freedom of Expression on Trial, the Case of Arnon Nampa in Thailand. This report illustrates through an emblematic case how restrictions on lawyers' free speech can undermine not only individual rights, but also the foundation of justice and democratic accountability. The report is part of our Free the Lawyers campaign, which highlights lawyers facing long prison sentences as a result of their professional work. Among these cases is the case of Arnon Nampa, a Thai human rights lawyer, whose case we have analyzed in this report, with a particular focus in his right as a lawyer to freedom of expression. Arnon has faced 14 prosecutions under Section 112 of the Thai Criminal Code. This is the lèse majesté law, which imposes up to 15 years of imprisonment for any expression deemed insulting to the monarchy. To date, he has already received sentence for more than 29 years, with several cases still pending resolution. The case of Arnon Nampa is not only emblematic of the risk lawyers face when exercising their right to freedom of expression, but also raises important questions about the role of lawyers in public debate. And I would like to return to that shortly. So first, why Arnon Nampa? And let me begin with an example that captures the essence of his case. On August 2020, Arnon Nampa stood before a crowd and called for an open public debate about the monarchy. He scrutinized the Crown Property Act and the transfer of public assets to royal control, and questioned the king's direct command over the military unit. It was a simple act of free expression, but those words were enough to turn a lawyer into a criminal. On September 2023, he was convicted for the first time under lèse majesté for a similar speech to this one. Since then, Arnon has faced over a dozen criminal cases, stemming from his participation in peaceful assemblies, his speeches, and his online expression. Beyond the criminal proceedings, he's also facing ongoing disbarment proceedings. He's a founding member of Thai Lawyers for Human Rights, who are joining us today. And as a lawyer, he has long defended activists, students, and ordinary citizens prosecuted under lèse majesté. By 2020, during the student-led pro-democracy protests, Arnon had become a prominent advocate for reform. And by choosing to speak publicly himself, he faced the same charges he had defended his clients against. And even in prison, he now continues to offer free legal assistance to others who are targeted under this same law. So his treatment by authorities has drawn a widespread international condemnation, including favorable opinion from the Working Group on Arbitrary Detention and several special rapporteurs and even the European Union. And to talk a bit about the context, over the past years, Thailand has seen a sharp rise in the misuse of criminal law to suppress peaceful expression. And at the center of this repression lies lèse-majesté. This law is vague, is broad, and is disproportionately used to suppress speech which lies into the protections of Article 19 of the ACCPR. And international human rights mechanisms have repeatedly raised alarm about this law. For example, the Human Rights Committee has repeatedly expressed concern about the severe use of lèse-majesté. In the last Universal Periodic Review, several states have raised concerns about this law and have specifically urged Thailand to ensure that lawyers can operate freely. And beyond this law, other laws have been used in Arnon's cases, such as the Computer Crimes Act, which have also drawn criticism because of their vagueness, the severity, and the potential misuse to curb dissent. So let's move on to the findings of our report. I would like to share some of the key points. And our analysis of the 14 lèse-majesté cases against Arnon Nampa reveals a pattern. Each charge arises from a peaceful exercise of his right of freedom of expression, specifically his advocacy for democratic reform and his open discussion about the monarchy. 11 cases concern public speeches delivered at demonstrations, and 3 of them arise from written statements or online posts. And to assess these cases, we drew upon international human rights standards, and some we would like to remind today are, for example, the General Comment number 34 from the Human Rights Committee, which makes clear that the protection under freedom of expression not only concerns any ideas, but also those that might offend or shock. So it becomes clear that debates on public institutions or public figures makes the level of protection even higher. The Human Rights Council also, through its resolution 12 from 2016, has made this clear, urging states not to restrict discussion on government policies, human rights issues, or peaceful political debate. And also, multiple human rights mechanisms have stressed that imprisonment is never an appropriate penalty for defamation. In its jurisprudence on Thailand, the Working Group on Arbitrary Detention has emphasized that and has said that even if a statement is considered defamatory, the appropriate remedy lies in civil action. So why does the role of Arnon as a lawyer matter? The indispensable role of lawyers, which has already been highlighted by Deborah very clear, it has been recognized by a numerous of international instruments, most recently through the Council of Europe Convention for the Protection of Professional Lawyers. And international standards make clear that lawyers must be free to perform their functions without intimidation or interference. And Deborah also mentioned Principle 23 of the UN Basic Principles on the Role of Lawyers, which refer to lawyers' freedom of expression and explicitly provides that lawyers should be permitted to take part in the public debate on matters concerning the law, the judiciary, and human rights. So this is not merely a personal entitlement, it's a professional responsibility. And these rights also extend beyond the courtroom. Lawyers' exercise of freedom of expression includes also commentary on the functioning of the justice systems and wider public concerns. And in contexts where the judicial guarantees are weak, these protections are even more important. So despite these guarantees, as also Deborah emphasized, attacks and reprisals against lawyers for exercising these rights remain widespread. And This has been a concern which has been highlighted by the Human Rights Committee, which recently said that individuals who gather and analyze human rights information, including lawyers, are more frequently targeted. And also by recent reports from the UN Special Rapporteur on the independence of judges and lawyers. So applying these principles to Arnon's case, we can see how Arnon's speeches and his posts are focused on issues of undeniable public interest: the constitutional reform, the management of public assets, the role of the military, and the misuse of lèse-majesté. So by prosecuting him for these public expressions, the authorities violated both his personal freedom of expression, but also his professional rights as a lawyer. Lawyers play a vital role in identifying systemic deficiencies, raising awareness about human rights violation, and advocating for legal reform. And that is precisely why they are entitled to this special protection under international law. And Arnon engagement exemplifies this role. In each speech and post, he analyzed constitutional reform, critiqued the scope of royal prerogatives, or called for legal changes. So the way that the law has been applied in his case also reveals selective targeting. In several demonstrations, there were multiple speakers, and Arnon was the only one charged. This pattern shows that his identity as a lawyer mattered, and this is also one of the points which is analyzed by the Working Group on Arbitrary Detention. And the court's reasoning went further. In one of the cases, the court held that Arnon, as a lawyer, should have known not to criticize the monarchy. So the rationale behind this is that his professional knowledge was used against him instead of protecting him. So to conclude, I hope I have transmitted how emblematic his case is. Arnon, his work embodies the public function as a lawyer, explaining the law, defending the law, and speaking truth to power. And he's not only the most high-profile Thai lawyer facing systemic harassment, but he's also a symbol of wider assault on the legal profession in Thailand. He, as I said, faces a cascade of cases, and each proceeding reinforces a message. The severity of these prosecutions suggests that his case serves as an exemplary punishment, and the result is a chilling effect that narrows the space both for lawyers to speak out, but also undermines the profession and the health of the rule of law. Thank you very much.
Thank you, Natalia, for this insightful presentation. And I think, as you said, the Arnon Nampa case is a very emblematic example of the wider trends that Deborah described in her earlier presentation that we see all around the world. And to deepen our understanding of the broader environment for lawyers in Thailand, we're joined by Akrache Chaimaneka Rakate. Akrache is an international human rights lawyer and the international advocacy lead at Thai Lawyers for Human Rights, a legal organization established after the 2040 coup to provide free of charge legal representation to individuals charged and or prosecuted for inter alia criticizing the government, the military of the Thai or the Thai monarchy. He will share reflections on the current challenges lawyers face in Thailand when wanting to exercise their freedom of expression. Akrache, the floor is yours.
Perfect. Thank you very much. And thank you again, everyone, for participating in this webinar, and also to Lawyers and Lawyers and Law Society for co-organizing this. Just to check, can everyone see the screen I'm sharing? Perfect. So just a bit about our organization. So Thai Lawyers for Human Rights, we were founded back in 2014, 2 days after the military coup overthrew the democratically elected government of Thailand. It was founded by a group of human rights lawyers who at the time anticipated that there was going to be an increased demand for legal representation, especially for those who were criticizing the military, criticizing the government, or criticizing the monarchy. And unfortunately, they turned out to be right. Primarily what we do is we document cases of human rights violations, especially political cases, that is to say, cases of people being prosecuted for exercising their fundamental freedoms. We also provide free legal aid to those individuals, and we do a lot of international advocacy work as well on top of that. But let's look at Thailand. I really want to look at the state of freedom of expression in Thailand. And here, I think we can look at this graph together. We were founded in 2014, and you can see that in the period between 2014 and 2020, usually our organization handled around 30 to 40 cases per year. As some of you may have heard, in 2020, there was a mass youth to 2021, in that 1 year, the number skyrocketed from 30 to 40 cases per year to more than 800 cases per year. That I want to highlight that to speak about the state of political prosecution in which we currently find ourselves in Thailand. Since 2020, since the movement swept the nation, almost 2,000 people, including more than 280 children under the age of 18, have been charged or prosecuted under various repressive laws, some of which have already been mentioned by my colleagues Natalia and Deborah. We look at the emergency decree used during the COVID years, purportedly to control the spread of the virus. We are looking at lèse majesté or royal defamation, which I will go into detail later. But if you look at lèse majesté or sedition, those are national security offenses. We look at illegal assembly, Computer Crimes Act, and contempt of court used against both activists and also lawyers who do their job in courtroom. Now, having understood the broader context of political prosecution, I really want to zoom into the crime of lèse majesté or the royal defamation charge. When we talk about lèse majesté, we are talking about a crime that says whoever defames, insults, threatens the king, queen, heir apparent, or regent shall be liable for imprisonment from 3 to 15 years. 3 to 15 years. That's equivalent to the penalty for manslaughter under the Thai Criminal Code. Manslaughter, same punishment as royal defamation. And it's not only that the penalty is really severe, it also happens that the conviction rate is really, really high. As you can see again from the graph, from the pie chart, almost 90%. We have an almost 90% conviction rate in lèse majesté cases, which is very, very high. And when people get convicted, there's a risk of really high disproportionate sentences. In January 2024, one of our clients was sentenced to 50 years in prison, 50, for sharing clips about the Thai monarchy on Facebook, including clips from John Oliver's Last Week Tonight show, where John Oliver spoke about the Thai monarchy. As Natalia mentioned, our colleague, human rights lawyer Arnon Nampa, has been sentenced to more than 29 years in prison. 29 years. By the end of this year, we think his sentence will exceed 30 years, 3 decades, simply for peacefully calling for monarchy reforms, calling for democratic reforms, and for peaceful participation in public assemblies. And the ambiguity and vagueness of lèse majesté renders the scope of the law extremely, extremely broad. For instance, people have been prosecuted for conducting a peaceful public opinion poll about the monarchy, for wearing a Thai traditional dress because the court deemed it to be a mockery of the Thai queen. A child convicted under the lèse-majesté law for wearing a crop top because the court said that the child was mocking the Thai king. Again, the overbroad nature of the crime makes the chilling effect that much more significant and that much more scary, unfortunately. And as I mentioned, since November 2020, the conviction rate has been really high. And despite the return to a civilian-led government after the 2023 election, the conviction rate actually increased after the transition from a military government into the civilian-led government from 74% to 88%. So even though we are seeing fewer new lèse-majesté cases today under the civilian-led government, the issue now is at the judicial level, because those cases that were brought back in 2020, 2021 that found themselves into the courtroom, judges are more likely than not to hand down guilty verdicts. Which brings me nicely to the next part about the judiciary. As I have said many times, the battleground for democracy in Thailand is no longer on the streets. It is in the courtroom, in the hands of judges. These are the people who hold the fate of activists, of lawyers in their hands. And when we look at judges, there are many problems. First, fair trial rights. For instance, many of the cases we handle are speech cases, people criticizing the monarchy, people criticizing the government. And they would be accused of lying in their speeches. So naturally, the defense would want to prove the veracity, the truthfulness of these speeches. But courts would refuse to issue subpoenas for the defense to help the defense get their hands on official documents that can easily prove the truthfulness of their speeches. Things like how much money was allocated from the national budget to the monarchy. Things like whether the king actually, in fact, traveled abroad from this period to that period. These are simple factual questions that can easily be proven in court, but courts refuse to help the defense get their hands on those official documents, thereby preventing the activists, the lawyers, from proving the truthfulness of their speeches. We also have courts recently trying to impose secret trial order. Despite the right to a public trial, courts sometimes try to impose a secret trial order, kicking members of the public out. And even when they don't kick members of the public out, even when they don't officially impose the secret trial order, they sometimes impose a gag order, preventing people in the courtroom from disseminating information about what happens in the courtroom to the public. There's an attempt to make these proceedings as secretive as possible, making it harder and harder for the public to have access to information. And when we look at impartiality of judges, many times judges would already be making a lot of negative comments about what the defendant's alleged conduct is, even before trial began. When we look at independence of judges, there's a 2019 Supreme Court regulation that says that judges have to submit draft orders or judgments to be reviewed by superior judges before those orders or judgments can be implemented, can be delivered. Again, that really raises a lot of questions about the independence of judges presiding over these political cases. And it's not only that, because having seen all these challenges together in the past few slides, it begs another question. What is it like for lawyers to operate in this environment, to operate in this restrictive environment? And a few examples I want to highlight. We have seen cases of reprisal. On your left, that's a lawyer, Sirikan Jalan Sili. She was actually initially charged with sedition for participating in the UN Human Rights Council procedure to raise awareness about her clients in Thailand who were being prosecuted in speech cases. Many of our judges, many of our lawyers were threatened with contempt of court when they argued with judges, when they asked judges to give legal reasoning as to why they wanted to, for example, deny the public from entering the courtroom. What is the legal basis for imposing a secret trial order. When you have that argument with judges, sometimes you get threatened with contempt of court. So again, that's really, really scary. And looking at Arnon Nampa, and this is the last thing I want to say. So Natalia talked about disbarment proceeding, about the professional rules being used against him in connection with that peaceful speech he made about the monarchy. But there's another case that I really want to highlight, and that's the case of the Harry Potter speech case, where last November, when the court kept refusing to issue subpoenas for Arnon Nampa so that he could prove in court that whatever he was saying about the monarchy, whatever laws he was criticizing, were truthful speeches that were based on facts, that could be easily proven by official documents. Court kept saying no. So Arnon Nampa kept asking why they would not issue these subpoenas for him. And so eventually he said, look, I'm not going to continue with the proceeding unless and until I get my hands on documents that can prove my innocence. And the court said, well, since you choose not to continue with the proceeding, we can end witness examination now and move straight to verdict. And that's what happened. They just cut out all the subsequent witness examination and moved straight to verdict, where he was found guilty of committing the crime of lèse majesté by giving speeches which were easily based on facts. Again, that's a state that we find ourselves in. And as you can see from the second bullet point as well, we were threatened with armed attacks for representing people in high-profile political cases. Earlier this year, we found out that our organization was on the high-value target list of the military, that they're keeping a close eye on the legal work that we do, because we represent human rights defenders and pro-democracy activists. That's the environment we find ourselves in. We have 3 simple recommendations. First, cease political prosecution and grant amnesty to victims of political prosecution. Second, drop charges against children and other people who exercise their fundamental rights. And lastly, in the event that they still go ahead prosecuting these people for exercising their fundamental freedoms, at least guarantee their right to a fair trial. Thank you very much.
Thank you very much, Akarachai, for this presentation, which I think clearly highlights the important work that Thai Lawyers for Human Rights is doing and how needed that is in Thailand. And thank you also for talking about the difficulties that you and your colleague face when exercising your professional activities. I think it's amazing that you continue to do the work under these circumstances. We now open the floor for the Q&A. Please use the chat function if you have any question, and we'll read it out. But maybe I can ask a first question first, which is to both Deborah and Akarachai, I think. We've briefly touched upon the role of bar associations in protecting the freedom of expression of lawyers. And I think we heard Akarachai and Natalia say something about the disbarment proceedings against Arnon Nampa. I would be interested in hearing a bit more about that, and whether that was also specifically connected to his right to freedom of expression and the reasoning behind that. And then maybe, Deborah, you mentioned a couple of recommendations, but I was also wondering whether you have specific recommendations for bar associations on this topic. What should bar associations do to prevent from the rights of lawyers being violated in these ways? Maybe we can start with Deborah and then go a bit more into detail with the Arnon Nampa case.
Yes, thank you. And it's interesting, I think, with bar associations and law societies, that they have a clear role to protect their members and to be protecting the legal profession generally. They can also be, unfortunately, also part of the problem. And those that aren't independent can also be weaponized against lawyers and members. And we've seen that, unfortunately, in a number of jurisdictions. So I guess the first thing is a recommendation would be that those bar associations need to function independently. They need to be separate from the executive. They need to have appointment procedures that are independent as well. Those that are independent and doing good work for members, I think one thing that needs to do is raising awareness around as has been mentioned, that lawyers' right to freedom of expression isn't just their individual right, but is a professional right as well, that it enables them to play the important role as public servants, and that targeting lawyers' freedom of expression and targeting lawyers in many different ways doesn't just impact on that individual, but impacts on the justice system generally, and has massive impacts across the whole of society. So we are not just speaking on behalf of lawyers, but trying to spread the message that protecting lawyers and ensuring that they can speak out on behalf of their clients, on behalf of also others in society, often those that are most marginalised and vulnerable, is really important. And bar associations can play a huge role in supporting their members, providing practical support, providing advocacy on their behalf, but also holding those looking at the legislation and commenting on legislation that's problematic. We mentioned a number of different types of laws that are misused. I think what they have in common is they're often very vague and overbroad provisions. So that needs to be tightened up to make sure there's legal certainty in laws. And also things like sedition laws. There is a growing trend to abolition of those, but we are seeing exceptions to that. But with sedition laws, they are arcane, they're often colonial remnants. And so, again, they need to be reviewed, need to be repealed. So bar associations can also play a part in advocacy towards that as well. Thank you.
Thanks, Deborah. And then maybe Akrajai, could you maybe say a bit more about the disbarment proceedings against Arnon and how, sort of what the reasoning was behind those?
Yes, of course. So I just want to echo Deborah's point about how lawyers' council or bar associations are supposed to be defending, protecting the rights of lawyers, including the right to freedom of expression. What we see in Thailand, unfortunately, is a lawyers' council that seems to be very hesitant, if not very silent, when it comes to political cases. That is to say, in cases where lawyers need protection most, in cases where lawyers take on the most risk representing people in political cases, that seems to be when Lawyers Council is most silent, unfortunately. And this is the case as well in Arnon Nampa, in Arnon Nampa situation. And as Deborah said, it seems that the Lawyers Council is part of the problem in this case, because the disbarment proceeding is initiated, is being, they are the one who are investigating Arnon Nampa for alleged breach of professional rules in connection with a peaceful speech he gave about monarchy reforms. So yeah, as Deborah said, they should be protecting his right, but they're the one investigating him, threatening him with disbarment for giving a speech peacefully calling for monarchy reforms.
Thanks, Akrajai. We got a question in the chat as well. I think to all speakers. What opportunities exist both domestically and internationally to strengthen protection for lawyers who face reprisals for exercising their freedom of expression? Who would like to take this question?
I don't mind speaking first. I think internationally, we've mentioned two key instruments, I think, that would be really important to raise awareness around. I think there is a lack of knowledge around the UN basic principles on the role of lawyers, which really sets a blueprint for the protection of lawyers globally. And as we mentioned, that does have an express provision guaranteeing lawyers' right to freedom of expression for the reasons we've mentioned, in order for them to be able to carry out their professional duties. There is now a really exciting opportunity through the new Council of Europe Convention for the Protection of the Profession of Lawyer. And this also protects lawyers' freedom of expression along with other rights. It's much more elaborate than the UN basic principles on the role of lawyers. And is also a treaty. So for those states that sign and ratify that, it is binding. It also will have a monitoring committee when it's in force. So although it's a Council of Europe convention, it is going to be open to all states to sign. So it is of global importance. And so again, raising awareness around that opportunity that the convention and the UN basic principles provide in order to showcase why lawyers' rights to freedom of expression and their rights generally need to be protected, but also to raise awareness around this convention and the opportunity maybe for other states to join, or to at least be taking the protections in that and applying them at the domestic level. So I think those are two key opportunities at the moment. Thank you.
Thanks so much, Deborah. Yeah, maybe to add to that the new convention is applicable to individual lawyers, but also bar associations and law societies, and also explicitly mentions the right to freedom of expression for bar associations, because I think next to individual lawyers being targeted, we also see around the world that bar associations who do speak out about human rights issues and contribute to the public debate are also being targeted through the same measures that are being used to target individual lawyers. So I think it's, like Deborah said, an amazing opportunity for countries to have broader protection for the freedom of expression of lawyers and bar associations. Thanks so much. Akrachai and Natalia, do you want to say something with regard to the question that was posed, or?
Yes, thank you, CT. Actually, Lawyers for Lawyers with other organizations, and well, of course, also Thai Lawyers for Human Rights sent a letter to Thai Lawyers Council when the disbarment procedures started, and we, of course, raised our concern. Also, the Special Rapporteur on the Independence of Judges and Lawyers sent letters to the Lawyers Council. But yeah, and coming back maybe to the previous question and opportunities, we think, of course, the role of lawyers is not one that comes as evident at first, as a role that needs to be protected. So our organizations advocate for that always. And one opportunity we have also used is the current negotiation, a free trade agreement between Thailand and the EU, in which we also send letters to the European Commission to take into consideration the role of lawyers. Maybe, Akrachai, you want to add something about that?
Yes, thank you very much, Natalia. Yeah, so on top of what Natalia was saying about the ongoing FTA negotiation between the EU and Thailand, as well as some of the letters that Lawyers for Lawyers sent to the authorities in Thailand, I think ultimately what those things do is to put a spotlight on the Thai authorities to try to increase the cause of rights violations, to let the Thai state know that they can't do these things without any consequences. And I think that's really, really important, because if we don't talk about them, if we don't communicate these things to the international community, then these things in Thailand and elsewhere in the world, and including in Thailand, can happen with very little consequences to be borne by the state, by people committing these rights violations. So yeah, I think those international cooperation, that's really, really helpful. Right now, we're trying to speak more to the European Union because as part of the FTA negotiation, they're supposed to do a sustainability impact assessment. And part of that SIA is the human rights impact assessment. And we hope that we would be able to raise some of these concerns, including concerns regarding the rights of lawyers, to counterparts at the European Union, for them to be aware of these human rights concerns, because it is part of their obligation too, to take these concerns into consideration as they negotiate for a free trade agreement with the Thai state. Domestically, and I want to say this very quickly, what we are pushing for right now, the Thai civil society, is for an amnesty bill to be passed so that we can grant amnesty to victims of political prosecution. In an ideal world, they should not have been prosecuted to begin with, but now that they are, the next best thing is to grant them amnesty. The Thai government talks a lot about political reconciliation. We can't move towards political reconciliation if Arnon Nampa and other people continue to be behind bars simply for speaking, and if people continue to be prosecuted for expressing dissenting views. So we think this amnesty bill that I think will be debated in Parliament next week, this is an important first step to unlock some of these political impasse so that the country can move forward together.
Thank you for sharing this, Karachai, and yeah, curious to see what will come out of the debate next week. Hopefully we can read about it on your website once the debate is done. I think there are no further questions in the chat, so I think we can, and unfortunately Ms. Karuna is also not here yet. She's still upholding court, so she's unable to provide us with her keynote speech. So I think we can conclude the event, and I want to thank all the speakers for their powerful insights. And thank you all for joining this important conversation. Thanks, Akrachai, for showing Arnon. I think the discussions today remind us that protecting lawyers' freedom of expression is not just about safeguarding the profession, but it's about defending justice and the rule of law itself. And I hope that together we can continue working to ensure that those who defend the law can also do that freely, fearlessly. Thank you all and have a lovely day.
Thank you.
Thank you so much.
Thank you. Thanks.